Come to order. Thank you all very much. I'm sorry I'm late. Today we'll have a hearing about the Reauthorizing the US FREEDOM Act of 2015. We got two panels. Basically, there are four parts of the act. I want the panels to tell us the good, the bad, and the ugly, why we need these four tools, why we need to reauthorize the program in your view, what happens if we don't, would you accept any changes, what would those changes be? And rather than me recite your testimony, I'm very interested in hearing from a national security perspective how the USA FREEDOM Act of 2015 is still relevant in 2019 and beyond, and the tools available to law enforcement and the intelligence community provided by this act, how they're relevant to the fight that we're still in. I would end with this. Baghdadi is dead, but the cause lives. The effort to penetrate our country is ongoing every day. Terrorist groups with a lot of different names are trying to come here to do us harm, to hurt Americans abroad, and the war is far from over. I wish it were, but it is not. There's no Air Force to shoot down. There's no Navy to sink. There's no capital to conquer. This is an ideology that must be combated, and those who embrace this ideology embrace death. So the only way you protect America is to hit them before they hit you, stop them over there before they get here. And the only way you can do that is to find out what they're up to using acceptable tools within our constitutional democracy. With that, I'll turn it over to Senator Feinstein.
Thanks, Mr. Chairman. I'll try not to be redundant, but this hearing I think is important because it provides an opportunity to take a good look at provisions of the USA FREEDOM Act that are set to expire at the end of this year on December 15. These are Section 215, otherwise known as the Business Records provision, as well as Roving Wiretap Authority and the Lone Wolf provision. This committee actually played a key role in establishing and modifying these authorities. So I think it's really important that we weigh in from time to time on any legislative changes that might be needed. I want to just focus a few remarks on Section 215. Which allows the government to require third parties, such as phone companies, to produce business records. 215 was previously used by the National Security Agency to conceal hundreds of millions of domestic phone records. Congress prohibited this bulk collection in the 2015 USA FREEDOM Act, introduced by Senators Leahy and Lee. Now, instead of bulk collection by the government, records remain with phone providers and are searchable only with a FISA order for a, quote, specific selection term, end quote. And that's generally a specific phone number or address. This call detail record, which we call a CDR, is meant to ensure that surveillance is sufficiently targeted. But in June of 2018, NSA publicly announced that due to technical irregularities, the CDR program had received data that it was not legally authorized to receive. Moreover, the agency could no longer distinguish between records that were obtained lawfully and those that were obtained unlawfully. As a result, NSA announced that it would delete all call detail records acquired over the last 3 years. In August, the Director of National Intelligence, Dan Coates, confirmed that NSA had suspended the CDR program indefinitely due to its lack of intelligence value, as well as its cost and compliance issues. Despite this, the administration is asking Congress to permanently authorize this program. Now, it's really not clear to me why a program with limited intelligence value and clear compliance problems should be reauthorized. And unless there is good reason to believe that it should, I do not believe we should reauthorize it. Thank you very much, Mr. Chairman.
Thank you, Senator Feinstein. Our first panel is Brad Wiegmann, Deputy Assistant Attorney General, National Security Division, Michael Orlando, Deputy Assistant Director for the Counterterrorism Division, Susan Morgan from the National Security Agency. Mr. Wiegmann.
Chairman Graham, Ranking Member Feinstein, members of the committee, thank you for the opportunity to testify today about 4 important provisions of the Foreign Intelligence Surveillance Act, or FISA. These are authorities that will expire at the end of this year unless they're reauthorized by Congress. The administration strongly supports permanent reauthorization of these provisions. 3 of the authorities, the roving wiretap, business records, and lone wolf provisions, have been part of FISA for well over a decade. They've been renewed by Congress multiple times, most recently in the USA FREEDOM Act of 2015. But before that, these same authorities were reauthorized multiple times between 2005 and 2011, and each renewal gained bipartisan support. Today, I'm going to give you a brief overview of 3 of the legal authorities, and then I'll turn it over to my colleagues from FBI to address how they've been used in practice and their value to national security. Then my colleague from the NSA is going to address the 4th authority, the CDR authority that Senator Feinstein described, under which NSA can engage in targeted collection of telephony metadata in counterterrorism investigations. So first, the roving wiretap authority. This enables the government to continue surveilling a FISA court-approved national security target when the target takes affirmative steps to thwart the surveillance. So these are individuals who rapidly and repeatedly change communication service providers in order to evade government monitoring. The roving provision allows us to continue surveillance without having to go back to the FISA court for a new order each time the target switches his phone. The government has used this authority in a relatively small number of cases each year. These cases tend to involve highly trained foreign intelligence officers operating within the United States who use these counter-surveillance techniques, or other important investigative targets, including some terrorism-related targets. The Wiretap Act on the criminal side has for decades contained a similar roving provision for ordinary criminal investigations of, let's say, a drug dealer or organized crime figures who may also take steps to thwart surveillance. Second, the Business Records Authority. This allows the government to apply to the FISA court for an order to collect records, papers, and other documents that are relevant to an authorized national security investigation. It allows the government to obtain many of the same types of records that it can obtain through a grand jury subpoena in an ordinary criminal case. For example, it can be used to obtain driver's license records, hotel records, car rental records, shipping records, and the like. In most cases, these are records the government obtains in an ordinary criminal or civil investigation without any court order. A FISA business records order is typically sought because national security interests preclude the use of less secure criminal authorities, or because there may be no criminal investigation underway in something that's purely an intelligence matter. This authority has been used several dozen times a year on average over the last few years. The business records provision is also the mechanism for the targeted collection of CDRs from U.S. telecommunications service provider. My colleague from NSA will discuss in a few minutes that this provision provides a way for the government, pursuant to a FISA court order, to identify telephone contacts of suspected terrorists who may be within the United States. Finally, we have the lone wolf provision. This enables the government to surveil a foreign person who's engaged in international terrorism, but who lacks traditional connections to a terrorist group. It also applies to foreign persons engaged in international proliferation of weapons of mass destruction. The government has not had occasion to use the lone wolf authority to date, but it fills an important gap in the government's collection capabilities where isolated actors are concerned. It allows for the surveillance of a foreign terrorist who might be inspired by a foreign terrorist group, but who is not technically an agent of that group. So for an example, it would allow surveillance of a foreign person who has self-radicalized through viewing propaganda of a foreign terrorist organization on the internet, or a known international terrorist who severs his connections with a foreign terrorist group. Use of any of the 3 authorities I've described today requires approval from the FISA court under standards that Congress has prescribed in law. Each of them also requires strict rules governing how the government must handle any information that is obtained concerning U.S. persons. Each of them is also subject to extensive executive branch oversight, as well as congressional reporting requirements and oversight. And as I've said, each has been renewed by Congress multiple times in the past. With that, I'll stop and turn it over to my colleagues.
Good morning, Chairman Graham, Ranking Member Feinstein, and members of the committee. Thank you for the opportunity to testify today about important provisions of the USA FREEDOM Act that will expire later this year unless reauthorized by Congress. These provisions have been integral to the FBI's success in many national security investigations. While I will likely not be able to get into specific examples of our use of these provisions in an open setting, I will do my best to provide you with thorough hypothetical use situations which demonstrate the critical role these tools play in national security investigations. I have seen the necessity of these provisions throughout my time as both a counterintelligence agent and a counterterrorism agent, and I am looking forward to answering your questions today. National security threats have evolved significantly in the last 20 years, from the proliferation of mobile smartphones to the expanded use of end-to-end encryption. New technology has allowed our threat actors to work increasingly in the shadows. Today, we have nearly universal access to the internet, and anyone with a cell phone can view and become radicalized by extremist content. Our subjects are no longer forced to travel to other countries to communicate with other extremists who threaten the security of the United States. Instead, they can do this from their home. Because of this, we also witness a shift towards individuals acting alone with multiple ideologies and without clear ties to any one foreign adversary. Our window for identification and disruption is shrinking. As these threats have evolved, Congress has helped us ensure we are prepared with the appropriate tools to continue to protect the U.S. and its interests. I'm here today to talk about the expiring provisions, which the FBI uses with FISA Court-approved oversight. As my colleague from the Department of Justice explained, we use the business records provision to obtain records or other tangible things for use in a national security investigation. We often describe the business records provision as a building block authority. That means we use it during the early stages of an investigation to build our case against national security threats. It is important to note the responses to business record orders do not contain content. The information we get from a business records order often helps us meet the legal threshold needed to get an order from the FISA Court for more advanced investigative techniques such as a wiretap. For example, once we receive the business record returns, if the suspected terrorist is communicating with a known bomb maker, we would have relevant information to help establish probable cause for a wiretap. Similarly, if we receive business record returns showing that the suspected terrorist is buying bomb-making materials like nitrogen-based fertilizer and large amounts of ball bearings, that information can also help us establish probable cause. The roving authority detailed in the USA FREEDOM Act is also an important provision that counteracts efforts by various national security threats, including terrorists and intelligence officers, to avoid court-authorized surveillance. These individuals often employ tactics such as using multiple burner phones or regularly creating new email accounts. Without this roving authority, we would struggle to maintain awareness of our targets as they purposely take action to thwart surveillance. We use this authority regularly in our national security investigations as a tool to avoid missing critical intelligence that would be lost if our ability to initiate surveillance was delayed by the need to obtain a FISA warrant on each new facility. The last authority the FBI requests you reauthorize is the lone wolf provision. Even though it has not yet been used, we believe it is critical to our national security toolkit. Homegrown violent extremists are among the FBI's top threat to the homeland. These individuals are, by definition, not in direct collaboration with foreign terrorist organizations. Homegrown violent extremists are often self-radicalized online through terrorist propaganda and motivated to attack with no specific direction from individuals associated with a foreign terrorist organization. Rest assured, the lone wolf provision is narrowly tailored, as it only allows use against non-U.S. persons. These authorities are critically important in our fight to keep the American public safe. The FBI urges Congress to reauthorize these authorities because we are confident they will continue to play an important role in the FBI's national security investigations as our adversaries continue to advance. Thank you for the opportunity to appear before you today. I'm happy to answer any questions related to these authorities.
Chairman, Ranking Member, distinguished members of the committee, thank you for the opportunity to testify today about the National Security Agency's Call Detail Records Program. The authority for the Call Detail Records, or CDR program, is among the important provisions of the Foreign Intelligence Surveillance Act that will expire at the end of this year, unless reauthorized by Congress. Congress added this authority to the Foreign Intelligence Surveillance Act 4 years ago in the USA FREEDOM Act as one of several significant reforms designed to enhance privacy and civil liberties. It replaced NSA's bulk telephony metadata collection program with a new legal authority whereby the bulk metadata would remain with the telecommunication service providers. As this committee's 2015 report described, the CDR authority provides a, quote, narrowly tailored mechanism for the targeted collection of telephone metadata for possible connections between foreign powers or agents of foreign powers and others as part of an authorized investigation to protect against international terrorism, end quote. Critically, the provision authorizes the collection of certain metadata associated with telephone calls, such as the originating or terminating telephone number and the date and time of a call, but does not authorize collecting the content of any communication, the name, address, or financial information of a subscriber or customer, or locational information. As this committee is aware, the NSA recently discontinued the CDR program and deleted the records acquired under the CDR authority after balancing the program's intelligence value, associated costs, and compliance and data integrity concerns. NSA's decision to suspend the CDR program does not mean that Congress should allow the CDR authority to expire. Rather, that decision shows that the executive branch is a responsible steward of the authority Congress affords it. As technology changes, our adversaries' tradecraft and communication habits continue to evolve and adapt. In light of this dynamic environment, NSA supports reauthorization of the CDR provision so that the government will retain this potentially valuable tool should it prove useful in the future. Thank you again for the opportunity to testify today. I look forward to your questions.
Senator Leahy, you'd like to make an opening statement?
I would, and I appreciate that. I was proud to join with Senator Lee in requesting this hearing, and I think I speak for both Senator Lee and myself. We thank you for holding the hearing as chairman. You know, I'm proud of our successful efforts in 2015 to pass the USA FREEDOM Act. This is the first major overhaul of government surveillance powers in decades. It added significant privacy protections for the American people. Now, though, because we said at that time we didn't be able to look at it, see how it works, we have the opportunity to learn from and assess and respond to what's happened over the past 4 years. So what have we learned? We know that the government issued only 14 CDR program orders in 2018, but they collect over 434 million records relating to over 19 million phone calls. Did all that with their 14 orders. We know of at least 2 incidents of significant overcollection. In fact, it resulted in the NSA purging all of their records and ultimately decommissioning the program. We know that then DNI Director Dan Coates acknowledged, even as he requested a permanent reauthorization of all the authorities granted in USA Freedom, that the CDR's program's relative intelligence value was negligible. Given all that, what don't we know? Unfortunately, quite a bit. We're only a month away from these authorities expiring. We don't know what caused the massive overcollection, what companies were responsible, or why it was not feasible for the NSA to identify or isolate the improperly produced data. And it's not as though Senator Lee and I have not tried to learn the answer to these questions. I mean, our questions are not of a partisan nature, where we try to make sure that this was not a Republican or a Democratic issue. It was a issue that the United States Senate cared about. Almost a year ago in December 2018, Senator Lee and I wrote a letter to the DNI and Justice Department asking these and other questions. We failed to get a response. So almost 7 months later, in July, we wrote again. Unfortunately, we've yet to get a substantive response to either of these letters. Despite this, despite not answering our question, the government is now requesting the permanent reauthorization of all of the authorities granted USA Freedom, including the CDR program. And they argue that, well, it might eventually be useful and technology might evolve to the point they could collect metadata in compliance with the law. We might be able to obey the law. Now, let me be clear. Maybe someday it'll be of some use. Hopefully, we'll develop technologies to not again violate the law. Well, that's not appropriate justification to reauthorize these powers, saying, if you reauthorize them, maybe we can actually follow the law. If at some point in the future the technology developed to allow for metadata collection that is appropriately limited, that follows the rules, that's fair, well, then come back to Congress and let us revisit the question. Until that time, there's no reason to reauthorize the CDR program. We're going to be legislating in the dark. So, Mr. Chairman, I thank you for holding this hearing. I look forward to the testimony, but let's not say, let's not pass a wish. Let's pass substantive legislation. And again, I thank you, but I thank Senator Lee, who has worked extremely hard on this.
Thank you. Ms. Morgan, why haven't you answered their letters?
Sir, my understanding...
Did you get the letters?
Sir, my understanding is that the letters were addressed to DOJ and the OG&I, so I would defer to my DOJ colleague.
Sorry, wrong person.
I can address that.
Who got the letters?
So they're addressed to the Director of National Intelligence, the Attorney General. So let me say first right up front, Senator Leahy, Senator Lee, other members of the committee, my apologies for not being able to respond to the letters thus far. My understanding is that they were held up originally so that the administration could develop a position on whether to seek reauthorization of these authorities. That happened in August of this year, so there was a significant portion of the delay was due to the administration developing a position on this. We have since worked on the letters to develop the position on seeking the authorities.
Well, this is
my apologies on that.
November, right?
Absolutely. So let me just tell you when I found about
from August and November.
We now have a draft response to the letters. You will have it this week. I was hoping I could bring it to the hearing today, but you will have it this week without fail. And we're also all here to answer your questions today. I'm happy to address the questions that were raised in the letter or between the three of us. So again, all I can do is apologize for not having gotten them to you, but we will answer your questions this week.
They're going to get an answer to the letter
this week.
This week.
Absolutely.
Well, that's progress.
Mr. Chairman, I know it's not my turn. I just want to interject here. If it takes 11 months to get a response to our letter, and if it takes nearly more than 6 months to even get the policy out, that itself didn't answer the questions, which was apparently the condition precedent for your ability to issue the letter, you've still had many months pass between the issuance of the policy and today. So perhaps, Mr. Chairman, the only way to do this is for us to have monthly hearings so that we can stay in contact on this. And I say that in dead seriousness. We're not messing around here. These are the privacy rights and the constitutional rights of the American people. We represent them, and we don't appreciate a nearly 1-year delay that is not warranted. And it adds deeply to my suspicion, and I appreciate Senator Leahy's working with me on this, and Mr. Chairman, I appreciate your working, helping us get this hearing, which I hope will be a monthly exercise now on.
Yeah. Well, there's no real good reason not to answer, letters by 2 senators who authored legislation to change the program. Having said that, the lone wolf provision, what do we lose if it goes away in real world terms?
Sir, this past year, we arrested approximately 100 terrorism suspects, international terrorism suspects. We're seeing more of the homegrown violent extremists. These are individuals who are not taking direction from...
But we've never actually used this provision, is that correct?
Yep. To date, we've been able to either disrupt them without it or been able to make...
Could you speak up a little bit closer to the mic?
Directly into the mic.
Yeah, apologize.
To date, we have not had to use it because we've been able to either disrupt...
Well, what do you lose if you don't have it?
The threat is evolving. With the more harm, we may have a need for it in the future.
So these people fall into space where you can't get a warrant, but something's going on.
Yes. And with the way the threats are evolving,
there's going to be more of that, less.
More of those who are being self-radicalized and taking direction. And so therefore, the potential for us to use that tool will probably increase in the future.
So this is really driven by the self-radicalized
Self-radicalized, and I would also say
non-U.S. citizen, right?
non-U.S. citizens, and I would also say the foreign terrorist organizations are also involving their capabilities and seek to use clean operatives that we may not be able to tie directly to them.
The roving surveillance part just makes common sense. If they change technology, you don't have to start all over again, right?
The roving technology has to do is when we're surveilling them and they're changing their technologies.
So I'm good on that. So the business records thing.
Yes, sir.
Tell us how that's used and what would you lose if it went away?
So we use it as mostly a building block tool. So for example, when a homegrown violent extremist starts to mobilize the violence, oftentimes they seek to procure weapons such as knives, rent vehicles to ram people. The business record gives us the ability to get the sales records so we can disrupt them faster. If we would lose that authority, the tangible things reduce down to just a few items that we can seek, and the evidentiary standard would increase that we would have to show beyond relevance that that is directly related to a foreign power.
Okay, Ms. Morgan, about the phone call monitoring, for lack of a better CDR, whatever you call it, why should we reauthorize it if you shut it down?
Sir, thank you for your question. As we mentioned earlier, as the committee mentioned earlier, the authority that was passed was carefully a tailored balance between privacy and civil liberties and national security needs in a counterterrorism context. We've used this authority responsibly and have been transparent with all three branches of government in terms of how we've used this authority and the challenges that we faced. The authorities granted to us by the Congress are really a set of tools in a toolbox that we can use and leverage in different ways.
Is this a technological problem you have?
I'm sorry, sir?
Well, you shut the program down for a reason.
Sir, we shut the program down because when we looked at the value that we were getting at this particular point.
But didn't you have a technological problem? Didn't you say the technology is not where it needs to be?
Sir, the challenges that we faced with this program, which
I mean, it's just odd that you shut down a program because the value of it is less than the cost, and you want us to reauthorize it.
Sir, when we look at our programs, we try to look at them in the context of what's available to us in terms of the different tools in our toolbox. When we look at this program, there was value there, but it didn't outweigh the cost, and we felt the responsible thing to do was to stop using the program. And
Why is it responsible for us to reauthorize it?
I think it's responsible for you to consider reauthorizing it because 1 year from now, 2 years from now, 3 years from now, I can't predict what the dynamic international terrorism environment is going to look like, and I can't predict what the telecommunications landscape is going to look like. We could find ourselves in a situation where this particular tool in our toolbox, we would want to have the agility to use it should it be valuable moving forward.
Thank you. Senator Feinstein.
Yes, let me just carry this out. The call detail record program, that's the successor to bulk collection under Section 215, was recently shut down by NSA due to lack of intelligence value, cost, and technical problems. Can NSA provide an example of information obtained from the CDR program that resulted in the discovery of a previously unknown terrorist plot?
Ma'am, thank you for your question. I'm certainly happy.
The answer is yes or no, essentially.
Ma'am, in an open setting, I can't answer that in a yes or no context due to class.
I'm not asking you for any detail. All I'm asking is, has there been a result in the discovery of a previously unknown terrorist plot? Yes or no?
Ma'am, I apologize, but I can't give a yes or no answer to that in an open. I'm happy to, at your convenience in a closed setting, give you any details that you need to make informed policy decisions.
Well, you want the program to be reauthorized, and I've been on the Intelligence Committee for a long time. We have to have the reason to reauthorize.
Yes, ma'am. I believe the reason.
So the reason is there a product?
Ma'am, I believe that the reason to reauthorize is that when we look at the international terrorist threat, it evolves over time, and as does technology. And we like to have the agility in place so that if this authority could provide us value in a different context, in a different way within the confines of the law, that we would have that tool on the shelf for our use.
Can you give any specific example of its help?
Ma'am, in an open, unclassified setting, I can't give.
No, come on. Does it help?
Ma'am, there has been value to the program, most certainly, over the past several
Well,
years.
what's that value?
Sir, to speak to specifics on that value, I'd have to do that in a classified session, which I'm more than willing to do at your convenience.
I'm sorry.
I'm just saying, look, that's inadequate. I've been on the Intelligence Committee for 26 years now, but we're in a public arena, I understand that. But if you can't give us any indication of specific value of the program, there's no reason for us to reauthorize it.
And we're not asking for any specific disclosures here,
Yes,
as I understand
that's
it. We're simply asking for, have we ever won anything through this?
Mr.
And when you
Chairman.
can't answer that question in public, that is a really tough position.
And if
Mr.
not,
Chairman,
there's a skiff right down the hall,
I was just gonna
100
say-
yards from here. I will go there right now.
I'm in a different position substantively than Senators Leahy and Lee. I'm a defender of your program, but I also agree, if you can't answer this question, why don't we go to a SCIF right now? Why can't we?
Well, why don't we just go ahead and do it? Let's go get through the other parts, then we'll have a classified hearing.
Yes, that's a better idea. Don't do it now.
Sure.
Debating this, 4 years ago, the then NSA Deputy Director
Well, here's the good news. You got
said
the
there's
committee
only one
engaged.
occasion. He said there's only one, and this was an open session. There's only one occasion when the phone records collection was uniquely valuable. One.
Okay. Well,
He said an open session.
we'll go to a classified setting.
Hey.
Go ahead, Senator Feinstein.
So you can't provide an example of information obtained from the CDR program? If Congress reauthorizes Section 215's business records provision, but ends the CDR program, the call detail record, will the administration support that?
Ma'am, as you know, I'm here representing NSA. I can't speak, I don't make policy decisions for the administration, so I'd have to defer to the administration.
Okay, next question. NSA received 3 years' worth of Americans' phone records that it was not legally authorized to receive. Moreover, the CDR program was shut down for failure to produce useful intelligence. Yet NSA is requesting reauthorization. Can you explain that position?
Ma'am, I'd like to clarify, it's entirely possible I'm not being clear, and I apologize. There was value in the program when it was instantiated. We did obtain value from an intelligence perspective. However, when we weigh that against the cost, we made the decision that the best step to take was to shut down the program. There have been issues with some of the data that we received from the different telecommunication providers, and I can go into those issues in detail.
Well, have the compliance problems been solved? And you're on the record.
So, ma'am, the compliance problems associated with this particular program have been solved as the program is shut down.
So the program was shut down.
Yes,
Is that
ma'am.
correct?
Yes, ma'am.
And what was the reason for shutting
Is
down?
everybody good with these other three provisions?
Yeah, well,
If there are, we'll just
Can
go
I
to the
finish?
classified thing. Go ahead.
what was the reason that the program was shut down?
Ma'am, the reason that the program was shut down was that we evaluated the program in terms of what value we were receiving from the program, and there was some value there. When we weigh that against the costs of the program, the resource costs, and we also took a look at, the issues we were facing from a compliance and a data integrity perspective, we also take into account what our other authorities bring to the counterterrorism fight, and we ultimately made the decision in that context to stop using the program.
Okay.
Thank you.
Senator Grassley.
Why, this would be for any of you, three of you, why is a clean reauthorization preferable to repealing or amending the most controversial provisions of the law? And I suppose concentrate on amending the most controversial provisions of the law.
Sir, I'm assuming we're the most controversial provision of the law. So what I would say is that we support the administration position of a clean reauthorization, and one reason for that is so that we have agility by having tools in our toolbox. The counterterrorism fight, as you know, I'm sure you're all aware, it evolves over time. So if we come across a situation where we think this authority can give us a tool that can help us see the overall international terrorism picture, we want to be able to move as quickly as we can to try to leverage that authority, and that is why we're supportive of a clean reauthorization.
If I could just speak to the other authorities.
Go ahead.
From my perspective at DOJ, this is, I think, the fourth time the other authorities have been reauthorized. That doesn't count some other interstitial ones that were done. So again, this is a decision for the committee and the Congress, but eventually I think the idea of a sunset is that you become comfortable with the basic authorities, and at this point, since they've been reauthorized so many times over the last 20 years, our view was at some point the Congress should decide that they're comfortable with them, but obviously we defer to the committee and the Congress if they want to continue having reauthorizations, but these have been reauthorized, the ordinary uses of these authorities on at least 4 occasions. So.
Let's say you can't legislate everything in detail, but you folks have heard about the privacy and civil liberties concerns. What are you doing to address those concerns on a daily basis as they come up? Because that's what we got to be satisfied on.
So I don't know what the privacy concerns are with, let's say, take the roving example. I think it's a straightforward authority. It's routine. I don't think there are any significant privacy concerns or controversies associated with that, so it shouldn't be a problem. Likewise, the ordinary uses of the Business Records Authority, these are things, again, as I mentioned earlier, you can get with a subpoena in an ordinary criminal case. We have more process in a national security case, significantly by going to the court, all the oversight that's required than you would in an ordinary criminal matter. So I really don't think the ordinary uses of these authorities should be controversial, should raise significant privacy or civil liberties concerns.
Is the law effective in carrying out the intended use and powers of the authorities being considered today? If not, explain what changes are necessary.
Again, we don't think changes are necessary. We think the authorities are appropriate as they stand today.
Yeah, I'll yield back my time.
Including the CDR thing?
I'll let NSA address the CDR program.
I'll let you decide.
Who's next? Senator Leahy, is he gone? Senator Whitehouse? I don't have a list of y'all. Okay.
Well, I'd like to thank the chair and ranking and the witnesses for your testimony and your service to our country. This is a critical opportunity for us to discuss the best ways to balance our responsibility for keeping Americans safe while also protecting the core protections of our Constitution, our civil liberties that are fundamental to our democracy. Ms. Morgan, in your testimony, you emphasized that the NSA's decision to discontinue the CDR program is based on, and I think I'm quoting, balancing the program's intelligence value, associated costs, and compliance and data integrity concerns. What metrics does the NSA use to determine a program's intelligence value broadly?
Sir, thank you for your question. There's a number of factors that we take into consideration when we're looking at the value of a particular program. So one would be, are we issuing any foreign intelligence reports that contain information from this particular program? As the committee likely knows, NSA gets intelligence requirements from different interagency partners, from policymakers. And did we find intelligence that was valuable enough for us to take the time and effort to disseminate, say, an intelligence product?
And did you?
Yes, sir.
So the characterization of this CDR program as having negligible value given against massive overcollection, you would argue that at least with that metric there was value?
Yes, sir. I would say there's value. The other thing that I think might be helpful to understand is when we're fighting the counterterrorism fight, we're using different authorities to get different pieces of information, and we're trying to connect those different dots. Mm-hmm. It's entirely certain that you might have information from one particular authority that in and of itself, it's not binary that now I suddenly have a counterterrorism outcome. It could be that you're building upon that, and weeks, months, even in some cases years later, you have an outcome, but you'd have to trace it all the way back. Oh, that little piece of information actually did have a contribution. So you really have to consider it as part of a broader picture.
You discovered that you'd improperly collected records in this CDR database massively. Is it correct the NSA deleted all of the CDR records that it held?
NSA deleted the CDR records that we received from the providers. We were authorized to retain records that underpinned SIGINT reports. We're authorized to retain that information.
And is there any indication that the deletion of these records has actually interfered with our counterterrorism efforts? Has
No.
there been any loss in intelligence value as a result?
Sir, I think that's something that is impossible to answer. Every day we're making trade-offs. So for example, when I was an analyst, every day I would say, should I look at this piece of information? Should I look at this piece of information? Because you can't look at everything. So there's no real way to know if I've lost a piece of information that could have been valuable.
One of the arguments that's being made is that the communications landscape is changing and it's tough to predict where technology is going, and that there's new types of digital communication that bad actors might reach each other, in particular including encrypted messages. Do records from encrypted messaging services fall under the scope of either the business records or the CDR authority? Mr. Wiegmann, Ms. Morgan.
The question is whether you can get things that are encrypted? Is that the question?
Yes.
So the Business Records Authority could not be used to get communications content in any of that, encrypted or unencrypted. You'd need a full content FISA for that.
Sir, under the program that we're currently not operating, we're only authorized to get metadata. Things like phone number A was in contact with phone number B at this date and time. We're not authorized to get any content, any encrypted messages.
Right. But are you able to get records, that metadata, about encrypted messages?
So I'll say my answer, and I'm going to look to Mr. Wiegmann to correct me. My understanding is that in the law it says specific selection term is what we're authorized to seek a permission from the FISA Court to collect information related to a specific selection term. So if there was a specific selection term and we got the authority from the FISC and there were metadata records, again, responsive to that, I believe we would be authorized to get that.
I think that's right. And so the same thing, I think that's right of the CDR program as Susan described it, but also true for the ordinary Business Records Authority. If we were to get what's called electronic communications transactional records, which is one of the uses that we have for 215. So that's metadata, so it might be to-from information. That information is typically not encrypted. So the message itself might be encrypted, but the metadata, i.e. who's communicating with whom, what the date was, et cetera, that kind of thing, we could get that type of information. It's not encrypted generally.
With your current authorities. Let me ask you a last question, if I could, Mr. Wiegmann, about the Privacy and Civil Liberties Oversight Board. They've made a number of suggestions regarding the role of amici in the FISC, including expanding the types of cases they can participate in, improving their access to materials, and being able to trigger appeals. If implemented, what would the impact of those changes be?
So I'm not familiar with the PCLOB's recommendations. Is it a recent report or?
I believe so.
Huh. I have not seen that. So you mentioned one was appeals?
The role of amici, essentially broadening their capacity to engage.
So I think the system right now is working pretty well. We've had amici appointed in about a half a dozen cases. They provide value, benefit to the court. It's up to the court to decide if they want an amicus to participate, which I think is appropriate. So the court can decide, would it benefit me to hear a different position, or is this essentially a routine matter where that's not necessary? So I think leaving that with the court is a good idea. On appeals, which you mentioned, we thought about this in 2015, when we worked with members of the committee to think about could the amicus file an appeal. There were constitutional issues with doing that because they're not a party to the case, so they wouldn't have standing under Article 3 to pursue an appeal themselves. So what we came up with in the current law is a certification mechanism whereby the court can certify the issue to the FISC-R, which is what we call the FISA Court of Review. Obviously, the amicus could suggest to the court that certifying the matter on appeal is appropriate. So it's kind of similar. They could have that mechanism, but we think there'd be constitutional issues with having an actual appeal right vested in the amicus. I don't know if that answers your question, but.
Let me follow up with you if I can.
Okay.
I recognize I'm out of time, but I do think this is a procedural improvement that might well be worth our considering. Thank you. Thank you.
Senator Cornyn.
Ms. Morgan, you're having to answer some tough questions here today, and you don't make this policy, do you?
No, sir, we do not set policy.
I don't know what you all did to deserve the ritual flogging that you get at the hearings like this, because I know none of you are the policymakers. But let me just ask, to me, it sounds to me like the oversight provisions in the law actually worked in the case of these call records. Let me go through that with you. First of all, the Congress writes the Foreign Intelligence Surveillance Act, which provides the authorization, but then the intelligence community has its own internal operating rules to try to comply with the law that the Congress has written. And then you have to apply to the Foreign Intelligence Surveillance Court. There is a judicial oversight, and then there is the congressional committees, the intelligence committees in the House and the Senate in particular that have oversight. Did I get that correct?
Yes, sir, and additionally, we have oversight from the executive branch in the form of DOJ and the Office of the Director of National Intelligence. Internal to the NSA, we have a robust compliance program. We have an Inspector General. We have a Civil Liberties and Privacy Officer who reports directly to the Director of the National Security Agency.
Well, my point is this is not a case where the FISA Court caught you or Congress, through its oversight, caught the NSA doing something that it shouldn't do. This is where your own internal procedures identified a problem. Is that correct?
Yes, sir. The challenges that we faced when we received records that had irregularities in them were self-identified and self-reported to the overseers in all three branches of government by the National Security Agency. We took methodical steps to address those different issues that we faced to resolve them.
And again, just to recapitulate, this is foreign intelligence, correct?
Sir, this particular program, the CDR program, is focused on international terrorism. So activities associated with international terrorism, trying to get insight into those activities and putting together pieces of the puzzle to help protect the country against international terrorist activities.
And the metadata, just to go through this again, because I think it's commonly misunderstood, it's not content, right?
Sir, that's correct. We do not receive any content, and in the data irregularities, when we face those challenges and those issues, we did not receive any content. We did not receive any locational information, subscriber information, voice communications, messages of any kind. It's solely things like phone number A in contact with phone number B at this date and time.
And I know this sounds almost trite because we say it over and over and over again. We talk about connecting the dots, but that's what we're talking about here, isn't it?
Absolutely, sir. In the international terrorism fight, you're dealing with people using different technologies, communicating in different ways, trying to hide their communications. And you want to have the different tools in the toolbox, and you want to have that agility because you really just don't know what you might face in the future.
Can you tell me whether is the NSA undertaking the efforts to deal with the technical problems that it encountered with the CDR program, or have you put that, just suspended that entirely?
Sir, we've suspended that entirely. We've taken down the infrastructure that supported the program as it was instantiated.
Yeah. Well, I think there are legitimate questions on whether Congress ought to reauthorize it. I hope, Mr. Chairman, we go ahead and we authorize the other three pieces of this, which, as we've heard from the Attorney General and Director Wray, are essential law enforcement and counterterrorism tools in this instance. But I think it would be helpful to have some additional classified testimony with regard to examples of where these tools have been useful, things that maybe you understandably cannot talk about here in public, and we certainly understand that. I just don't want us to be in a position of not reauthorizing something that might ultimately develop into a tool in this continuing changes in the strategy and tactics of terrorists, and then have a hearing like this after some Americans have been killed and wonder, why didn't the NSA, why didn't the FBI, why didn't the Department of Justice do more? And Congress is not particularly nimble when it comes to reauthorizing new laws, so I think we ought to be very careful about letting this one lapse. Thank you, Mr. Chairman.
I think very good suggestion. Senator Lee.
Thank you, Mr. Chairman. Ms. Morgan, when you spoke to the House Judiciary Committee earlier this year, you declined to answer whether the CDR program had materially contributed to preventing a terrorist attack. You said you stated, and correct me if I have this wrong, but you believe that was not an appropriate measure of the CDR's program's value. Well, I don't find that answer sufficient. When we were debating the USA Freedom Act 4 years ago, the then NSA Deputy Director Chris Inglis publicly testified, that there's only one occasion when the phone records collection was uniquely valuable in a counterterrorism case. He called it a but-for connection. Now, I'd like to have at least as much transparency as we had 4 years ago. Since passage of the USA Freedom Act, on how many occasions, I'm not asking you what they were, but on how many occasions was the CDR program materially significant in preventing a terrorist attack? 5, 10, 25, 0, what?
Sir, if I may just clarify something you mentioned about what I said to the House Judiciary Committee. What I thought I said, and I don't have a transcript in front of me, is that prevention of a terrorist attack is but one metric of a program's value. It's one factor. So just to clarify that, I'm not saying that that's not a valuable factor. I'm just saying it's only one measure of value. I just want to clarify that.
But that's why I asked the question, on how many occasions has the CDR program materially significant in preventing a terrorist attack, if any?
Sir, again, and I apologize, I recognize this must be incredibly frustrating. At the time of this discussion we're having right now, that information is classified, and I'm unable to divulge.
Not even the number?
Sir, I'm not able to go into those details in an open session. I apologize.
Can you say whether it's more than 0?
Sir, I'm really uncomfortable in terms of classification.
The NSA Deputy Director before testified there was only one occasion. That's 4 years ago. In the 702 context, the intelligence community regularly promotes that Section 702 is instrumental in preventing attacks on the homeland and removing terrorists from the battlefield. And they say that publicly. If the NSA says that about Section 702, but they're unwilling to say anything about CDR collection under Section 215, it would seem the CDR program by itself doesn't prevent terrorist attacks on the homeland.
So, sir, again.
Is my reasoning?
So again, sir, what I would say is that in the 702 context, decisions were made on what would be considered classified and not classified. I don't make those decisions, but in this context, the information you're asking me about is currently classified.
I think we are going to have a classified hearing, Mr. Chairman.
Yeah, I promise you we will.
When the Director of National Intelligence at the time in August acknowledged that the CDR program's relative intelligence value does not outweigh its costs, saying even by NSA's own metrics, the CDR program is not sufficiently valued to be worthwhile. Is that what I should read from that?
Sir, I would say I think you should read from that currently, absolutely, the value does not outweigh the cost.
Thank you very much.
Thank you.
And these questions aren't directed at you personally. We're just trying to get some information here because we have to, like Senator Lee and I and others have to vote on these things. Mr. Wiegmann and Mr. Orlando, how many times has CDR information been used in criminal investigations or prosecutions by the FBI or the Justice Department? I'm not asking you which case, I'm just asking you how many times.
So I'm aware of one.
Okay. Orlando?
I'm not aware of any, so I would have to concur with Mr. Wiegmann's statement.
Thank you. Mr. Wiegmann, you were asked in September during the House Judiciary Committee hearing whether doorbell videos from the home security company Ring could be obtained with a Section 215 order. You said you believe so, but you'd have to check that and confirm. Okay, that was a couple of months ago. And so now I'll ask you 2 months later, can the government obtain a Ring video under Section 215? And what about heart rate data from a Fitbit or photographs stored in the cloud?
Yeah, so let me answer that question. During the House Judiciary Committee, what I said was that I could definitely see that surveillance video would be relevant and would meet the relevant standard of a business records request. So that's something that would be within the scope of records that you could seek with a business records order. I think whether any particular surveillance video would be obtainable would depend on the particular facts. So let's take, for example, you're at a bank, an ATM machine where they have a camera, or they have at a gas station, they have a surveillance camera at the gas station, and there's a terrorist that stops him for gas or whatever, you want to get that video. I think in that context, that's something that you could get with a subpoena in an ordinary criminal case, and you could probably get that therefore with a business records order. Other types of systems where ECPA, the Electronic Communications Privacy Act, might come into play because you're storing that video with a provider would raise different issues, right, in that scenario, because that's more like stored content for which might be protected by the Fourth Amendment and would be something you could not get with a warrant. So just to clarify, it really depends on the facts. What I was saying in the House side was that it is not like ruled out that you can't get surveillance video. It would depend on the facts and in the particular case as to whether you could get it. If you could get it in a criminal case, you could get it with a business records order. If you get it with a subpoena. If it's something that's protected by the Fourth Amendment, absolutely, we could not get it. You could not get Fourth Amendment protected content with a business records order. So does that answer your question?
It comes very close to answering.
Okay.
And I appreciate it. Thank you, Mr. Chairman.
I'm happy to follow up if there's other aspects to that.
That was fascinating. Senator Lee.
Thank you, Mr. Chairman. Thanks to all of you for your willingness to serve our country in an effort to make us safer while protecting our privacy rights. As I've said before, our privacy and our security are not at odds with one another. Our privacy is, in fact, part of our security. We are not truly secure unless our privacy rights are also protected. I want to thank Senator Leahy for his work with me on these issues over the years. Senator Leahy and I have been aligned. There's been no distance, no daylight between us on these issues. And one of the many issues that we've covered, in addition to introducing the USA FREEDOM Act together, relates to something that you, Mr. Wiegmann, mentioned just a minute ago, the Electronic Communications Privacy Act. This is a law passed when I was in the 8th grade, and it's a law passed at a time when no one had personal computers, no one had email, outside of a small handful of people in government and academia. No one had email. And as I read that law, it does give the government access not only to metadata surrounding email, but also to the content of email, as long as that email has ripened to the age of 6 months. This is stunning. So coupled with the authorities that we're talking about here, I think that ought to be of concern to every American. Most Americans are very concerned when they find out that this is the case. In fact, most Americans are very concerned when they find out about most of these authorities. It's one of the reasons why these hearings are so important and why I hope to make them not just a regular, but a monthly occurrence. And if we need to have some of these in the SCIF, so be it. But we need to get answers to these questions. Mr. Wiegmann and Mr. Orlando, I'll start with you. What's the FBI's working definition of tangible things in the context of business records?
Our definition is per what's in the provision: books, records, papers, document, other items, airline records, hotel accommodations, storage facilities, vehicle rentals. It also provides for some sensitive items such as library circulation records, book sales, book customer lists, firearm sales records, tax records, educational returns. Those types of documents, we would need a higher level of approval. These are the same things that could be gotten by a grand jury.
Okay, so would that definition encompass medical records?
According to the provision, yes.
And would medical records also include, and not exclude from its purview, mental health records?
So I think with all of these, we would have to show relevance, that this information is relevant to the investigation.
I understand that, but it still fits within the definition.
I believe so, but on each individual case, and I'll defer to Mr. Wiegmann, is that we would have to look at, does this violate a Fourth Amendment issue, in which case we would have to go for a search warrant.
To answer your question, Senator Lee, it's right in the statute, because in section 1861A13, it talks about the fact that you can apply for the production of, as is mentioned, library records, book sales, book customer lists, tax return records, educational records, or medical records. It's in the statute that Congress has given us, so it's expressly addressed.
Understood. DNA test results also, presumably. People enter into a
That's right.
contract.
And again, just to be clear, we're talking about the more exotic things. We are not using this authority to get these types of records. It's not clear what the relevance would be in any particular case. It's just that it's possible, it's conceivable, this could come up. But these are not the garden variety uses of the Business Records Authority. I want to be very clear about that. The things that we're getting typically, as I mentioned earlier, electronic communications, transactional records we get shipping records, we get driver's license records, things like that. So
I appreciate that. And I appreciate the fact that you were absolutely correct in pointing out you were administering a statute that was passed by Congress. You are not the lawmaker. We are the lawmaking body within the federal government. We made this law, and you're telling us what it says. Our job is to figure out whether and to what extent we should reauthorize those and whether and to what extent we ought to change it. I think most Americans would be alarmed to find out the ease with which the federal government could, more or less on a whim, as long as it can check a few necessary boxes, obtain someone's medical records, including mental health records, obtain tax records, including what charitable organization or church or synagogue or mosque they happen to donate to, the records of their searches on Google or other internet search platforms, their conversations as overheard by Amazon's Alexa or other similar technologies. And so when you put this much power in the hands of the federal government, one has to worry. The fact that you don't use them all the time is not, in my mind, a satisfactory response from our standpoint. Again, this says nothing about you and about what you're saying. We're talking about us as lawmakers and whether or not it's a complete dereliction of our duty to protect the Fourth Amendment rights of the American people to give this much power in the first place to government officials. If you asked most of King George III's officers if they were inclined to abuse writs of assistance, or if they were inclined to abuse general warrants, they'd say no. We only use this for good things, for the king, for the country, for God. And they would claim that they didn't abuse them. You ask most British subjects, including and especially most American colonists at the time, and they would take quite a different view. One of the many things that worries me about this is the fact that we're told that a number of these things will very rarely ever be sought. And yet, given the evidentiary standard that is deemed permissible to obtain these records, this is of great concern to many Americans, including and especially me. This is not exactly something that hasn't gone unabused in the past. And when you look at the Church Committee reports from back in the 70s, they analyzed the abuse of telephone recordings, basically since the development of the telephone as a commercially viable option. In every presidential administration, starting with the beginning of the use of the telephone, up through the presidential administration in power at the time those committee proceedings were commenced, those in office had abused the American surveillance and law enforcement and espionage agencies to engage in political espionage. We know that these things can happen, and when they can happen, they do happen. And that's why we've got to tie a really tight set of restraints around it, because it will be abused. This is, unfortunately, human nature.
Thank you. Senator Blumenthal. Senator Blumenthal.
Thanks, Mr. Chairman. Thank you for having this hearing. You know, I think most Americans never heard of the FISA Court before the Mueller investigation. Most people now, when they think of the Mueller report, think of Carter Page. They think of what they've read in terms of the challenges to the warrant issued there. There have been charges that the warrant for surveillance was the result of an illegal partisan scam engineered by political enemies in order to affect the outcome of the 2016 election. And so I think in terms of justifying to the American people that the FISA Court operates fairly and effectively, I raise this question. Do you think that the experience in that instance indicates that anything untoward happened either in applying for the warrants or in the FISA court granting the warrants, from what you know? Let me ask Mr. Wiegmann and Mr. Orlando.
So I can't comment on that, A, because I don't know the answer, and B, because that's under an IG investigation. So I think that issue is being examined by the IG right now, and we're waiting on the report, and we'll see what the report says.
I have to agree with Mr. Wiegmann. I wouldn't be able to comment, and there is an IG investigation. They would be the appropriate individuals to talk about.
Well, let me put the question in a different way. Do you believe that there is a need, putting aside Carter Page, for FISA court reform?
I don't. I think the FISA court operates really well. I think there's extraordinary amount of oversight. I think the level of attention, in other words, that goes into every FISA warrant is extraordinary. It's a very time-consuming and extensive process. Only very senior officials at the department, only 3 officials can authorize a FISA warrant, so it's at the highest levels. And you contrast that with, I don't want to disparage our ordinary criminal cases, but it's significantly different if it's a drug dealer or an organized crime figure and so forth. So we have quite an elaborate regime for approval of these mechanisms, high standards. We have extensive oversight. So I think this, from my perspective, the system is working pretty well.
Do you agree?
I agree. I think if the American public was able to see the rigor in this process, they would be very surprised about how much goes into protecting their privacy. And I'd like to also add is when you look at the FISA business record, that also goes to an independent judge, unlike a grand jury subpoena on a criminal case where there's no scrutiny about it. So I believe there's a lot of rigorous protections in place.
The scrutiny given to a FISA warrant is substantially greater than a grand jury subpoena.
Dramatically so.
Right, where in a grand jury there's virtually no scrutiny.
Right, that's right. And again, just to mention something that Senator Lee said earlier about the types of records, just to be clear, the Business Records Authority cannot be used to obtain anything that you could get that is protected by the Fourth Amendment, just cannot. So we can't get any of those things. And I just want to mention, because I didn't get to a chance to address it, there are separate statutes that protect, let's say, tax records and medical records and so forth. And in giving my answer, I didn't want to suggest that if there are separate things that Congress has already enacted, the interplay between those statutory restrictions and the Business Records Authority is something that I wasn't kind of opining on. And so in the event that we were to use the Business Records Authority, we would have to consider the effect of those statutes on whether you have the authority. So all I'm saying is we have the same, the authority that we have in the business records provision is the same, right, as what we have in a criminal case, right? So there's nothing different. It gives us greater authority to get the sensitive type of records than could be obtained with an ordinary grand jury subpoena. So it's important to keep that comparison in mind. There's not something more intrusive or more extensive on the national security side than on the criminal side. In fact, it's less because we have additional oversight and additional requirements. So I just want to make that clear. There's nothing special about the national security side.
Even though you took a lot of my time in answering.
I'm sorry. I apologize. I apologize for that.
Senator Lee's question, but it was a good question. Let me raise one last issue. In 2012, the Solicitor General, Donald Verrilli, assured the Supreme Court that any criminal defendant who was being prosecuted using evidence discovered directly or indirectly through surveillance authorized by Section 702 of the FISA Amendments Act would receive notification of that fact. That kind of notice is essential, as I think we would agree. Without it, defendants have no ability to challenge the lawfulness of surveillance that's used against them. It's one of the key mechanisms for ensuring the lawfulness of all government action, and it disappears if there's no notification. After Mr. Verrilli made that representation, it became clear that the Department of Justice was not, in fact, informing criminal defendants when Section 702 surveillance had been used to build a case against them. I know that the law and DOJ policy have changed since then, and so I hope this question is going to be an easy one for you. Does the Department of Justice always inform criminal defendants when the case against them is built on evidence gained through Section 702 surveillance?
Just I want to be very surprised when you say built on. The standard in the statute is evidence that is obtained or derived from use of 702 is used against an aggrieved person in a criminal case. then absolutely we would comply with our legal obligations and would provide notice to the criminal defendant in that context. So all of those elements have to be met. It has to be an aggrieved person, which is essentially a person on the communication. So it could be that the information is used, but the person wasn't a communicant, in which case we would have no obligation to notify that person because he wouldn't have an interest in an ability to assert a standing to suppress that information. So you have to meet those requirements, but if that is the case.
If not a communicant, he is not, or she, not being surveilled.
That's right, but communications of other people could be relevant in that person's case. And so in that case, he's not an aggrieved person. We would not give notice to them, but those other things could be relevant in their case, if you're following me.
Let me ask you about Section 215. Does the Department of Justice...
Senator, we're about 2 minutes over here. I'm sorry.
Oh, I'm sorry. Well, he took 2 minutes of my time, but...
See if you can...
I'll submit my questions in writing.
I think I know your question, but Section 215 does not have a notice provision. The reason for that is, as I explained earlier, there is no Fourth Amendment event. It's not Fourth Amendment protected, so there's no suppression remedy under 215 either. So it's a different thing. So there is no notice mechanism, and so we don't provide notice. So that's what Congress has prescribed, unlike the other provisions of FISA, if that was your question.
Thank you.
Senator Kennedy.
Thank you, Mr. Chairman, and thanks to all of you for being here. I've listened carefully. Look, I know you have difficult jobs, and I know your colleagues do as well, and I thank you for the jobs you do. By and large, you've kept us safe, and I appreciate that. I'm not sure how much progress we're making today. I understand that there's little that you can tell us in a public setting. You'll probably be somewhat reluctant in a private setting, classified setting, and I understand that. This place leaks like the Titanic, usually for political advantage, and I really, really regret that. It would seem to me that when we do this again, Mr. Chairman, we could invite our three friends here back, but also the policymakers. Put yourself in our shoes for a second. We can't see what you see, so we have to assume the worst. That doesn't mean it's an accurate assumption, but Senator Lee made the point well. Government has been known to abuse its power. And none of us want to look around one day and see that America has a social credit system like China. We don't want you to become as powerful as Facebook. For all I know, Facebook has our DNA. But that's a separate topic. And let me give you an example. I guess it was back in the late 60s, President Johnson had decided not to run for re-election. He was in the middle of the Paris peace talks. He received information that then candidate and later President Richard Nixon allegedly was interfering with the Paris peace talks for political reasons. I don't know if it's true or not, but there was credible information. And but President Johnson couldn't say anything because he got his information through illegal wiretaps. We don't want to end up there again. I don't understand, and in the little time I have left, I hope you'll help me. On our call detail records system, was it shut down because of technical difficulties or because of a cost-benefit analysis?
Sir, I would say that it was shut down. It was suspended because we did a cost-benefit analysis, but we couldn't do that in isolation and not take into consideration the other factors such as the data integrity and compliance concerns that we faced. So we don't operate in a vacuum, so we would weigh all the different factors to include those to try to come up with a comprehensive and really thoughtful position on how to proceed with the program.
You're not a policymaker.
No, sir.
But I've been very impressed with your testimony and your candor, given the circumstances. If you were a policymaker, and perhaps you should be, would you renew the program?
Sir, what I'll say to that is that I support the administration's position because I honestly believe it's the best position to have with respect to this program.
And why is that?
So the reason that I believe that is that, as I mentioned before, the way terrorists communicate and the way technology evolves, it's not out of the realm of possibility, certainly, to say we might find a new technology out there that we've never even considered or thought of. Those terrorists might be using that technology, and perhaps the way we could get insight into their contacts, again, just metadata with one another, would be to leverage this particular authority. And I want to be able to have the ability to move as dynamically as possible in trying to get at those communications once a decision would be made to say, yes, we think the potential value of that authority and how we would apply and leverage it would outweigh the resource costs. And we're confident in our ability to execute that authority in compliance with the laws, regulations, and policies that govern us.
Thank you.
Thank you, sir.
all.
Thank you, Mr. Chairman, and thank you each for your patience and for being as candid as you feel that you can be in this setting. I will say I think most people looked at what transpired or what we now know transpired with the 2016 elections and the abuses with the FISA Court process and communications and actions between Strzok and Lisa Page, and they go, something needs to be done about this because we value our privacy. And we probably should have years ago put in place some online privacy guidelines and rules of the road, but Congress has not done that. People are just now becoming aware of much of this, and it is imperative that as we do these reviews that we do them right. And Ms. Morgan, you just spoke to evolving technologies. And we know that terrorists today don't pick up the phone and call somebody and say, this is what I'm going to do. They're using Signal, they're using WhatsApp, they're using Snap, SnapMap, things of that nature to move. And I do think it's important that you all be able to work and to evolve as these new technologies come into the marketplace and come into play. But I'd like for you, as much as you can now, and then when we go to a classified hearing, then be able to expand on how you are evolving and working with these new technologies and tracking the way adverse actors are using these technologies. If you'll give just a little snippet.
Ma'am, thank you for your very insightful question, and I'll do my best in an open setting. So what I would say is that, as I mentioned before, the laws that Congress passes and the authorities you give to us give us different tools and different options. Over time, we apply those authorities in different ways in the confines of the law, in accordance with the law and the regulations, as the technology changes. So the way that we might have applied a law or an authority when it was first passed, that's an evolutionary process that evolves over time.
And we need to make the appropriate changes. What we need to do is give you the tools that are going to be useful. And if there are changes that need to be made, we need your insight on that. Because we do not, as Senator Kennedy just said, we don't know what you know. So we are putting a platform in place, a guideline in place, the statutes in place, and then you're trying to come back in and plug what you're doing into those various holes and put those policies in place. And then you all are taking your actions based on that. So we need your help and your insight on that. I do have one other question, and of course we've all got lots of questions about Section 215, and I want to I tell you what, I'm going to wait and do that when we are in a classified setting with a question that I have got. on that. One thing I do want to hear from you all when we go to a classified setting, Mr. Chairman, the safeguards on the data that you are collecting and then that you're retaining and then the disposal of that. I think we need a little bit more information on that, and it would be inappropriate at this point. I realize that. So we'll look for that in a classified setting, and I'll yield back.
Yes, ma'am. Senator Hawley.
Thank you, Mr. Chairman. Thanks to all the witnesses for being here. Can any of you compare the amount of data, the amount, volume, type of data that the government has been able to collect using these tools with the amount, volume of data that private companies, and I'm thinking specifically of Facebook, Google, maybe TikTok, what are we looking at? Are they comparable? Has the government collected it or is able to collect much more? Do any of you have a sense of that? I'd just be curious to know.
It really depends on the type of information that you're talking about, but if you're talking about electronic information, we can only get the information with legal process that's targeted in a particular case. It depends on the companies, but a lot of the companies maintain, it's the data of their customers, but they maintain full access if that's the answer to your question for their own commercial purposes and so forth. So they would have access to vastly larger quantities of data than the government could get pursuant to legal process.
And not least because you do have to go through some sort of process. I mean, it varies, I understand, depending on what exactly it is you're collecting, but Google and Facebook and TikTok and whomever else, they don't have to go through, I mean, once they get their users' consent nominally, which they usually don't really even ask for, then they have access to geolocation data, search data, phone books, messages, et cetera, et cetera. Am I right about that?
Absolutely, that's totally correct.
Yeah. Switching gears just slightly, let me ask you about the business records provision in Section 215. How has the FBI used this authority over the last couple of years? Can you give me a sense? And what would it mean for the Bureau's ability to counter terrorism, other threats, if your ability to obtain business records information went away? Just give me some perspective on that.
We use it in a variety of ways, mostly as a building block. For instance, as I stated earlier today, in a terrorism case, oftentimes when a homegrown violent extremist begins to mobilize for violence, he attempts to procure weapons, whether a knife, or rent a vehicle, or a bomb-making material. The business record enables us to get those sales records to determine that he is doing that so we can disrupt him. Additionally, we oftentimes use the business records for electronic communication transactional records. That is, who are you communicating with, but not the content. That has been especially helpful in our counterintelligence investigations as we try to build out the networks that the intelligence officers are building to recruit U.S. persons. We also use that in the same way our terrorism cases as well. As far as what would happen if we lost this provision, what we would be able to acquire would be limited down to 4 areas. We wouldn't be able to get the totality or the equivalent of what a grand jury subpoena could get. In addition, in our counterintelligence cases, the only way we're able to get that electronic communication transactional records is through business records. Most companies don't comply with the national security letters. In counterintelligence investigations, oftentimes a crime has not been committed, so we wouldn't be able to declassify that information and then go to a grand jury for that. And then lastly, the standard for the business record would increase from relevance to the investigation to something higher to specific and articulable facts that this pertains to an agent of foreign power.
Thank you very much. That's very helpful. Let me ask you this. The biggest change, as I understand it, that came with the USA FREEDOM Act was the end of bulk collection of data. And I'm wondering what difference this has made operationally over the last 4 years and what, if any, changes need to be made to the current system of requesting detailed call records. Go ahead, Ms. Morgan.
So, sir, thank you for your question. So just to, if I could level set a little
Yeah,
bit
please.
between the 2 programs. So under the bulk program, the providers, the telecommunications providers would give NSA metadata. Again, we were limited to metadata, and they'd give it to us in what else characterizes an indiscriminate fashion. Whatever they technically could give to us is what they would give to us. Internally to NSA, there would be an approval process that the appropriately trained analysts would have to go through to be able to have, say, a phone number and look into that data. So that was the bulk program. Under the program that we just decommissioned that we're here talking about today, the process is a bit different. The providers hold on to the records in bulk. Our process is much more targeted. So what happens is an analyst might say, I have this phone number, and I have a reasonable articulable suspicion that the user of that phone number is involved in international terrorism activities. We would coordinate that with the FBI and with DOJ, and we would file through DOJ an application with the FISA Court. If the FISA Court agreed that we met the appropriate standard, then they'd be able to compel the telecommunication providers to give us records, metadata records only, associated with that particular phone number. Now, when you look at the two programs, there's, some differences in that, one being that now we have a court approval process in place now. So you could say, anything that has a court approval process in place is not as quick as something that doesn't have an approval process in place. So that's, one particular distinction. In terms of our data integrity and our compliance concerns, since those issues were related to the underlying data that we were getting from the providers, we assessed that we would likely have those similar kinds of problems in a bulk program as well, because it's just the mechanism by which you're getting that data.
That's helpful. Thank you very much. Thank you, Mr. Chairman.
Senator Cruz.
Thank you, Mr. Chairman. Thank you to the witnesses who are here. I think in 2015, when Congress came together and passed the USA FREEDOM Act, we were endeavoring to strike the appropriate balance between competing interests. That legislation was bipartisan legislation. My friend Senator Lee took the lead in passing it. I was proud to work alongside him in doing so. I think the objectives were, number one, to protect the civil rights of American citizens and to prevent the bulk collection of metadata from American citizens who had committed no wrongdoing and for whom there was no evidence that they were engaged in wrongdoing. And the USA FREEDOM Act took a significant step back in terms of the authority for government to surveil innocent American citizens. At the same time, the statute sought to enhance the tools to go after terrorists, to go after criminals, to go after those who pose a real threat to the health and safety of Americans. And I think that likewise is the right balance, that we want law enforcement, we want the intelligence community focused on the bad guys and not focused on law-abiding citizens. That distinction, I think, is right at the heart of the USA FREEDOM Act. I think it's the right distinction to have. I am not one who is interested in defanging our law enforcement or intelligence ability to go after terrorists and to surveil them effectively when there is real evidence of wrongdoing. But at the same time, we should not sanction the widespread violation of privacy rights of American citizens. So my question to the panel is a general one, which is we now have several years' experience under that statute, which got bipartisan support and passed into law. How is it working? Did Congress strike the right balance? Are there, number one, sufficient protections for the privacy rights of American citizens? And are there, number two, sufficient tools to go after people who pose a genuine terrorist threat? And I'll open that to anyone who would care to respond.
So let me address the three ordinary authorities, the ordinary business records, the lone wolf, and the roving authority. Again, as I said earlier, I think absolutely the authorities are appropriate. I think they've been implemented appropriately. They've been reviewed by the IG multiple times. This committee, as well as the Intelligence Committee, has full access to all the different uses of the authority. If anything novel is done, that's reported to the committee. So I think we have strong mechanisms in place to assure the authorities are being used appropriately. They're not used all that often either. The authorities are used selectively in these investigations. So I think we have a lot of process to authorize these tools. One could quarrel as to whether there's too much process, that they're too difficult to use, but I think we're comfortable with what we have now. I don't know if that answers your question.
I think when I look at the three provisions that mostly provide to the FBI, we haven't used the lone wolf, but on the other two, traditional business record 215 and roving, we've had a solid track record with it. believe there are enough checks and balances. If anything, I would say that most agents would complain that it's a lot easier to go get a grand jury subpoena if you could go do that in that case. So I think we have sufficient protections in place.
Yeah, so just to second that again, I think the most recent IG report on 215, the main complaint the IG had is, and the complaint from agents in the field is it takes too long to do this process, and so they would use other authorities, use maybe less secure authorities on the criminal side because those are easier to use.
Sir, thank you for your question. So I believe that, from our perspective, that it did strike the right balance. And while we've had challenges from a data integrity and compliance concern in implementing the program, I think the checks and balances worked. We took steps to address those challenges that we had. We self-reported to all 3 branches of government, for our overseers. So I do think that it struck the right balance.
So, Mr. Orlando, I think you used a phrase something like a solid record of results, something like that. Can you elaborate in terms of the benefits the tools have yielded?
I can. I meant to say we've had a solid compliance rate with these tools. There really hasn't been abuses with it, and they have been beneficial to us. On the roving authority, given how intelligence services train their intelligence officers to evade FBI surveillance, it has given us the ability to keep pace with them when they switch vehicles, switch phones, switch hotels. In regards to the business records, have been a very valuable tool in helping us build our cases. As I said earlier, regarding terrorists acquiring weapons, it gives us the ability to get ahead of those things much earlier on than if we didn't have that tool, especially when there's classified information. We do receive a lot of information from our foreign partners, the other agencies that are classified that we wouldn't be able to declassify, and it gives us the agility to protect Americans.
Thank you.
Thank you. Thank you all. You've done a really good job informing the committee and had some tough questions, but we'll work through it. We'll do a classified hearing to dig down more into the information and make sure we know what we should reauthorize and what we shouldn't. Anything else? Okay, thank you. Next panel, please. Thank you all. On this panel, we have Adam Klein, Chairman and member of the Privacy and Civil Liberties Oversight Board. Jamil, Jaffer, is that right? Founder and Executive Director, National Security Institute, Antonin Scalia School of Law, George Mason University. Elizabeth Goitein, Co-Director, Liberty and National Security Program, Brennan Center for Justice. Mr. Klein.
Thank you, Mr. Chairman and Ranking Member Feinstein. I'm happy to be here to testify today. My name is Adam.
We've got to vote at 12. If you can kind of, keep it a couple of minutes, that'd be great. We can look at your written testimony.
I'm going to revise my statement downward as I go. I'm Chairman of the Privacy and Civil Liberties Oversight Board, which is an independent, bipartisan executive branch agency dedicated to ensuring that efforts to protect against terrorism are balanced with the need to protect privacy and civil liberties. I just want to mention that my remarks today are in my individual official capacity as chairman and do not necessarily reflect the views of my 4 other bipartisan colleagues. We've talked a great deal today already about the contours and origins of the CDR program, so I'm going to skip recapitulating some of those things, which I think are already well known. And I'll talk about what our board has been doing on this program and what information we can provide to the committee. In advance of the upcoming reauthorization deadline, our board has reviewed NSA's collection of call detail records under the USA FREEDOM Act. That investigation involved months of fact-finding by our expert staff and by our bipartisan group of board members. We also held a public forum to receive outside views on the program. Recently, we submitted a draft report to the intelligence community for accuracy and classification review. That draft contains a comprehensive account of the technical and operational issues that occurred during the program's life. I'd like to thank our staff for their many months of hard work on the report. Now, at present, that document remains classified, but we are prepared to brief any senators and your staff at any time, including immediately after this hearing, in an appropriately secured setting on the details, which I think will answer many of the factual questions that have come up here today. And we certainly understand the committee's desire to receive that important information. I am also cleared to provide a few top-line conclusions at an unclassified level based on my knowledge of the facts that we found in our review. We found no malfeasance or abuse of this authority, nor did we find any instance in which government officials intentionally sought records that were prohibited under the statute. We looked and we found no evidence that NSA received any of the prohibited categories of information under the statute. And as a reminder, those prohibited categories would include the content of calls, the names or addresses of subscribers, financial information, cell site location information, or GPS coordinates. We also looked at the operational use of this program in great detail, and as I said, we're prepared to answer many of the questions that have been raised today about the operational use of the authority in a classified setting. As everyone knows, NSA chose to suspend the program after considering its relative intelligence value against other factors. And I can say my view, based on the facts that we reviewed, and again in great detail, that that decision was well supported by the available evidence. We also looked at the compliance concerns and data integrity concerns that led NSA to delete data and eventually influenced its decision to suspend the program. Our review of the facts surrounding those incidents confirmed that those challenges were inadvertent and were not willful. I also think it's important to note that when NSA received information that raised questions about the scope of what it was allowed to collect under the statute, the agency chose to follow a narrower understanding of its authority under the Act rather than a more expansive interpretation that would have given it greater leeway. And we are happy to provide the details supporting that judgment in a classified setting, either immediately after this hearing or at any time that would be convenient for senators or staff members. We hope that the review process on our work will proceed swiftly so that an unclassified report can be provided to the public at some point, and hopefully potentially a classified document to the committee and the Congress as quickly as possible. We are grateful to the intelligence community officials who have been working hard to respond to our many investigative requests and are assisting with that review process. Thank you again for the invitation, and I look forward to answering your questions.
Thank you. Chairman Graham, Ranking Member Feinstein, and members of the committee, thank you for having me here today. Today, obviously, we're facing a significant challenge. We're 40 days out from the reauthorization of the USA FREEDOM Act. If Congress doesn't act in the next 40 days, all of these authorities will go back to the pre-9/11 state of these authorities. That means that our ability to collect information through the 215 program, the Lone Wolf program, which has not been utilized, and the roving authority will go away, as will the CDR program and all the other benefits that came with the CDR program, the various privacy and civil liberties oversight enhancing measures that were put into the USA FREEDOM Act. So clearly Congress needs to act in the next 40 days and take some action to reauthorize some of these provisions and make the modifications necessary. Now, as you've already heard today about the relative value of and the potential value of Lone Wolf and roving, it seems like there's a little debate about that, and it seems like those seem like a sensible thing to reauthorize. As does 215, the base program of 215, where the government is able to obtain a variety of records well beyond what the original version of that authority provided prior to 9/11. So those seem relatively non-controversial, and given that they've been relatively non-controversial, there's no evidence of any misuse or abuse of those programs in the last 18 years since they've been around, roughly, with the exception of Lone Wolf, which has been around a little bit less time. It seems to make sense not just to reauthorize those, but to make those authorities permanent and to avoid having to run into the situation again of running up to the deadline and having a concern about losing authorities. Then we come to the final authority, the CDR, which has been the topic of much of the discussion today at the committee, and reasonably so. It was the issue in the 215 program that generated the USA FREEDOM Act, that generated the debate that we had, and ultimately led to the changes that were made in the program. And so the question is, why reauthorize the program if, in fact, NSA has chosen to deauthorize the program and is no longer using it? It's an interesting and important question. Today, the threat we face from terrorism feels more distant than it did on 9/11 and the immediate aftermath of those attacks. It feels even more distant than it did from the days we saw of other terrorist attacks that were happening with some regularity or attempted terrorist attacks in the United States. We've put terrorists on the run for the past 20 years by fighting them overseas. And yet they continue to be committed to attacking us both here at home and attacking our allies abroad and attacking Americans wherever they are. Those threats are clear. The DNI has repeatedly indicated that ISIS remains strong regardless of the fact that we have taken away their territorial habitat in Syria and Iraq. We know that ISIS's leader is gone today, thanks to the good work of our law enforcement, our intelligence, and our military communities, and yet they remain committed to attacking us here at home, as does al-Qaeda. It's important to remember that al-Qaeda remains a serious threat to us too. And let's not forget about the threat that Iran and its terrorist proxies pose this nation. We've gotten tougher with Iran in the last 2.5 years, and they remain committed. And they've begun to attack us and our allies overseas. We've seen the attacks against U.S. drones. We've seen the attacks against Saudi Aramco. And we've seen additional threats by Iran against the United States. So the threat of terrorism, whether through Iranian proxies, directly through al-Qaeda, or directly through ISIS, remains strong. So the question then becomes, what do we do about a tool that we might utilize but isn't being utilized today? Do we take it off the table and remove it from the toolkit that our operators might need on the day when they find a threat? Or do we look at it carefully, ask them to come back to us and tell us, if you're going to use it, let us know. Let us know how you're going to comply with the law. It strikes me that the right approach to this problem is to at least leave the authority available for operators to use. It's been modified significantly from what it was. The huge privacy concerns that were raised during the debate over 215 have now been addressed. There are still questions about the breadth and the scope of the collection and the collection that takes place even when you have a single individual, yet those things can be addressed through careful oversight that this committee conducts and continues to conduct. I will say, Senator Lee, it is embarrassing that the Justice Department was unable to answer your question for a year. When I was at the Justice Department under the Bush administration, we tried to avoid things like that. They do happen on occasion, but it's not acceptable. And it's not acceptable that you had members of the government come before you today and not be able to give you unclassified examples of the quality of the program. We know that the Justice Department has given us previously about a dozen unclassified examples of the use of 215. This is prior to the USA Freedom change. And some of those are credible. They demonstrate examples. None of them are the silver bullet. But you're never going to get a silver bullet in this type of collection. And if we're looking for silver bullet, we won't get that. Senator Feinstein knows that from her time on the Intelligence Committee. This is all about building blocks. And so what I would say to the committee is you're not going to find a silver bullet if you're looking for that. But at the same time, it is very dangerous. And it would be a mistake, I think, to take a tool off the table at a time when the terrorist threat remains high and substantive. Thank you.
Chairman Graham, Ranking Member Feinstein, and members of the committee, thank you very much for this opportunity to testify. The USA Freedom Act was the most significant surveillance reform in nearly 40 years. It was also a compromise and an experiment. Several reforms that were included in earlier versions of the bill were dropped or weakened in order to obtain the administration's support. Moreover, the mechanism that Congress innovated to try to prohibit bulk collection, the use of the so-called specific selection term, or SST, was a bit of a gamble. The definition of SST was left open-ended, which raised some concerns that in practice it might allow collection that was, if not bulk collection, at least bulky collection. The law has now been in operation for 4 years, and thanks to its transparency provisions, we have some insight into how it's working. The bottom line is that the law is not fully serving its intended purposes. Most obviously, the new phone records program established by USA Freedom is a failure. And I won't go into it because I'm trying to go a little bit faster, and we've talked about it quite a bit, but I will say this idea that an authority might be useful and might be compliant with the law in the future is an argument for giving the government unlimited authority, because you never know when authorities might be useful in the future. It is clearly time for Congress to pull this plug on this non-compliant and ineffective program. In addition, the government's statistical reports show that the SST mechanism is not working as Congress had hoped. Under each authority, including Section 215, also the pen register, trap and trace, and national security letters, the number of unique identifiers captured is orders of magnitude greater than the number of actual targets. What this suggests is that the government is choosing targets and/or SSTs that encompass hundreds or thousands of people. such as large companies or IP addresses that cover large networks of people. In doing so, the government is inevitably going to be sweeping in large amounts of information that has no relevance to any authorized investigation. That's the definition of bulky collection. Furthermore, since 2015, several FISA Court opinions have been disclosed showing systemic noncompliance by the government with the limits, the all-important limits that are in place to protect Americans' privacy and their constitutional rights. In one case that carries disturbing echoes of the NSA's bulk collection, the court chided the FBI for conducting batch queries of communications collected under 702. So under FBI procedures, each query is supposed to be reasonably likely to return foreign intelligence or evidence of a crime, but agents have been running queries of up to 70,000 people at a time on the theory that these queries in aggregate would return a hit. And finally, with respect, Mr. Wiegmann is not correct, and Mr. Jaffer is not correct, that there are no privacy or civil liberties concerns with the roving wiretap or lone wolf provisions, which I'd love to get into later if we have time. So in short, time has revealed significant gaps in the protections established by the USA FREEDOM Act, and Congress should take this opportunity to fill those gaps. As discussed in my written testimony in detail, Congress should end the Call Detail Records program, but also tighten the standards for collection under Section 215. Recognizing that some overcollection will continue to occur, Congress should enact strong minimization requirements. It should close the backdoor search loophole that underlies the FBI's batch queries and other warrantless searches of Americans' communications. It should implement the Supreme Court's holding in Carpenter versus United States, something the government has failed to do, by barring warrantless collection of geolocation information or similarly sensitive data. It should expressly prohibit surveillance based on race, religion, or other protected characteristics, as well as surveillance predicated on First Amendment protected activities. It should fill various holes in the law's transparency and oversight provisions, and it should allow the lone wolf provision, which has never been used in 15 years, to expire, and should amend the roving wiretap provision so that it matches the parallel criminal provision. So thank you, and I look forward to your questions.
Thank you. We have a vote at 12. We'll just keep going as long as we can. Mr. Klein, about the CDR program, do you recommend it be reauthorized?
Thank you, Senator. I want to first say that I certainly agree with Professor Jaffer that the terrorist threat remains.
I got it. Do you recommend it be reauthorized?
I agree that it was a correct decision to suspend the program. Now, whether it's useful to keep the authority waiting around depends on a few predictive judgments. Do you think that it's going to be useful in the future? And that would depend on how terrorists are communicating. Now, we heard testimony at our public forum. Obviously, that's different than hearing the greatest and latest classified information.
Where are you at on should it be reauthorized?
Yeah, and I think the point I'm trying to make, Senator, is that unlike the things that we can rest solid judgments on based on our retrospective look at the program, that's a predictive judgment about the future, and so the key factors are how are terrorists going to communicate? We know they're moving based on publicly available information to IP-based communication, to chat apps, to things like that, and not sticking specifically to telephony. To be sure, people still use phones, but I think you'd want to get NSA's judgment in a classified setting and other agencies about whether terrorists are going to be sticking with phones or whether a more multifaceted authority that takes in more types of communications might be useful. And then, of course, there's the issue of whether the technical challenges that were publicly disclosed with this program can be fixed. And I think we'd want to talk more with you in a classified setting to explain our view of what those issues were. And we'd be happy to do that immediately after this hearing or at any time that's convenient.
Okay. Ms., how do you say your name again? I'm sorry.
Goitein.
So let's say you have a scenario where somebody is trying to come in on the refugee program, or you just named the person a foreign national, and we find on their website urging people to embrace jihad. What do we do about that?
So I think that on its own, you say urging people to embrace jihad. I think it depends whether it reaches the level where it's either a true threat or incitement to violence. Those things are not protected by the First Amendment.
Let's say that the profile of this person gives us concern.
I think, again, it depends what you mean by profile. If profile has to do with their race or religion, then no. But if profile has to do with actions they've taken that suggest that they may actually be involved in some way in terrorism, then I think that that's valid.
What do you say, Ms. Jaffer?
No, I agree, absolutely. The challenge, of course, though, is that you can't get a traditional FISA court order against somebody unless they're an agent of a foreign power or a foreign
The
power.
whole point of the lone wolf.
Exactly right. That's
point
right,
I'm
Mr.
trying to
Chairman.
make.
Exactly right.
May I say one thing about the lone wolf provision, however? What the lone wolf provision does is it allows the government to get an order from the FISA court in a case where there is probable cause that a person is involved in or preparing for international terrorism. If you have probable cause that a person is preparing for international terrorism, you can get a criminal warrant.
So
That is why the lone wolf provision has not been used in 15 years.
What would you say, Mr.
Mr. Chairman, look, the fact of the matter is that's not the only reason. The reality is that there are times at which you don't have enough information to get a criminal warrant.
Isn't that the
but
point?
Yes, sir. Mr. Chairman, that's exactly the point. That's why the government has repeatedly asked for that authority. It's why Congress has repeatedly reauthorized that authority 4
Different standard
times.
than probable cause, but it's still a standard you have to meet.
That's right. It's probable cause to believe that they're involved in international terrorism. It's not probable cause to believe a crime has been committed. There's a distinction. You're right, Mr. Chairman.
So, Mr. Klein, all the problems associated with the CDR program, you believe the government's acted responsibly in terms of how they've handled this?
Yes, Senator, I do. And I think there are a couple key differences between this program and the former bulk program, the most notable of which is that this was based on a publicly debated, publicly enacted statute that clearly laid out the contours of what the government would be able to do under the program. And our review indicates that they made every good effort to follow those contours. There were some issues, but we judged that those issues were inadvertent.
So we should applaud them for basically self-regulating here, right?
Yeah, there's a compliance infrastructure in place. Any large human enterprise is going to involve some mistakes, and the question is, how do you respond to those mistakes? Do you take them seriously? Do you remediate? And do you tell the truth about what happened?
So one last chance to get you to answer my original question. All of us are up here worrying about how do we explain to our constituents to reauthorize a program that's been shut down, and what do we say the day after an attack? Did we do everything within reason to prevent the attack? If you had to say what's the wise decision in terms of, hedging your bets to keep the program around?
Yeah, I mean, with respect, Senator, and I don't mean to trivialize this program, but NSA operated this program for several years. They determined that the juice wasn't worth the squeeze. We looked at the juice, we looked at the squeeze. My judgment is that they made the right choice, and whether it's worth keeping that authority around in the future depends on whether they think they can squeeze the orange better in the future.
Okay, fair enough. Senator Feinstein.
Well, I sit on the Intelligence Committee, and there's no question that we should keep our protection devices up, and that there are people who would harm us if they could. And so I am categorically not for taking away any of the safeguards that this country has put in motion. I believe that it's our obligation to protect us. And I watch carefully, I do my background work, I read the intel, and there are a lot of problems out there. And the question I have is, how do we keep them from hurting this country? And I view that as my directive for my California constituents. So I am not for canceling out any program that exists. How we run it better? Yes. How we run it more efficiently? That's fine. But to begin to remove these now, with all that I know is going on in the world, I'm not going to be a vote to do so. I just want to make that clear.
Thank you, and Senator Lee, but can you sort of split this thing up? And from my view, the three authorities, the roving, wiretap, all make sense to me. It's just the CDR program seems to not have lived up to our hopes and expectations. I guess you could permanently reauthorize 3 and make a separate decision on the other, conditional, 2 years from now. I don't know, Senator Lee, what you'd be in the market for, but to not reauthorize it permanently, but give it another chance. I don't know if that makes sense to you, but Senator Lee.
Thank you very much. Mr. Klein, let's start with you. In your prepared testimony, you referred to a recommendation made by PCLOB in your 2014 report, which was really good, by the way. And we, in response to that, we added language to the USA Freedom Act, a section requiring a FISA court to select amicus curiae, to be able to present arguments in certain cases where there's an order that's necessarily going to involve a novel or significant interpretation of the law, as determined by the court, of course. In your view, does the FISA court utilize this provision as often as it should?
That was a recommendation made by my predecessors, but I strongly agree with it. I think it's absolutely essential to increasing the public credibility of the court, which after all is staffed by real Article III federal district court judges, and so it should be credible, but of course we also have the adversarial process in our normal courts, and we all assume, and I think we all agree, that that improves the quality of decision making. If you look at the public reports that are coming out about the number of amicus appointments, you will see an upward trend, and so I think that's a good thing. My personal inclination would be to try to ensure that the amicus is involved as much as possible, including in every matter where you can be confident that there's going to be a significant programmatic decision made. One example, and this is purely in my individual capacity that I've cited in the past, is the annual certification proceedings that take place under Section 702. That's different from a Title I FISA wiretap where you're looking at one guy and what that person may have done. This is a programmatic judgment about the safeguards in place for a large-scale collection program. And in my view, that's exactly the type of situation where you should, by definition, always have the participation of the amicus.
Would you consider going so far as to just say, let's have amicus participation in every case?
I wouldn't, Senator, respectfully. Most FISA court proceedings are analogous to warrant proceedings that take place on an ex parte basis in normal courts around the country. And judges, federal district court judges, are used to hearing those things and making those decisions in an ex parte matter, and I think that makes sense for various reasons.
I suppose some of the concern underlying what you're describing could be addressed by providing a carve-out for cases involving an emergency, but I suppose that's a different question. Ms. Goitein, I have some questions for you, but before we get to those, I sensed a few minutes ago that you wanted to respond to one of the arguments that was being made with regard to the lone wolf provision and the probable cause showing. Do you want to get to that?
Thank you. Yes, I just wanted to make sure that we understood that we were, in fact, talking about a probable cause standard. It's not lower than probable cause, and that we were talking about probable cause that a person is preparing for or engaged in acts of international terrorism. And if you look up the definition of international terrorism, it's pretty much what you might think. So the notion that somehow that would not be enough to get a criminal warrant, first of all, doesn't make a lot of sense on its face, and second of all, isn't borne out by the record. Right. It's not that it's not that the government hasn't been getting the information it needs, it's that it's been getting that information through other means because the lone wolf provision isn't necessary.
Right, and it's not necessary if it is at least as difficult as, but without the precedential track record of other mechanisms already available. Is that what you're saying? So why have it on the books if it's never used, and it's not likely going to be used because it doesn't really plow any new ground?
It's never been used, and it removes this principle of connection to a foreign power or agent of a foreign power that is the unifying principle behind when we use the FISA process as opposed to some other process. So it sort of opens the door to sort of gradually degrading the rights that are available to non-U.S. persons who are lawfully inside the United States.
You're creating a danger that's unnecessary given that it hasn't been used.
Exactly.
And how do you think Carpenter applies in the FISA collection process?
Sure. So the court in Carpenter essentially held that there are certain types of information that are so sensitive, so inherently sensitive in what they reveal about a person's life, that the mere fact that they're held by a third party does not eviscerate the person's Fourth Amendment interest in that information. And in that case, it was several months' worth of cell phone location data. Now, the court was very careful to say that it was limiting itself to the facts of the case. It said that this would not apply to, quote, other techniques that are used in the foreign intelligence and national security areas. But if, in fact, Section 215 is being used to collect cell site location information, that is not another technique, that is the same technique, so I think Carpenter would apply there. And while the court is not responsible for applying its general principles to cases that aren't in front of it, Congress can't avoid that, right? And the government can't avoid that. You need to figure out how, before reauthorizing this legislation, how you think Carpenter would apply to some of the other technologies and some of the other information that we know that the government is almost certainly obtaining through Section 215 orders. There are certainly other types of information, other ways of obtaining geolocation data, or other types of information that are similarly sensitive in what they reveal about a person's life, where the logic of Carpenter would absolutely hold. So I think that is something that Congress should be looking at now when it reauthorizes Section 215, in large part because the government has failed to do so. In March, we got answers from the Director of National Intelligence saying there had been absolutely no intelligence community-wide guidance on how to implement Carpenter, and then congressional requests for additional information since then have gone unanswered.
In other words, there's nothing magical or talismanic about uttering the words national security that creates some sort of loophole within the Fourth Amendment. You have things that the government may do, and you have things the government may not do. But that doesn't turn on whether you utter the words national security or put it in the context of a foreign intelligence investigation.
That's certainly correct with respect to domestic national security, and for foreign intelligence, Congress has in the past made the decision that the protection of a warrant or something like a warrant, a FISA court order, should apply when extremely sensitive information is at stake.
Thank you.
Thank you. This has been a great hearing. We'll do a classified follow-on about the program and just end with this thought. There's a difference between fighting crime and fighting a war, and I think I understand the difference. And we're going to preserve the tools necessary to hit the enemy before they hit us within our constitutional democracy, but there's a fundamental difference here between trying to prosecute an individual and prevent an attack on our country, and I think that's what this is all about. So we'll have a classified hearing, then we'll talk about what to do next. Thank you all.